All right, we're live. All right, welcome back, everybody. Another session with Blair Johnson for Due Process with Dads. I'm James Gunter, co-founder and executive director at Present Pillars. Have with me Blair Johnson, attorney. And today we'll be covering custody and parenting time. So hope everybody's doing well in the new year. Really looking forward to having a great year here at Present Pillars again. 2024 was amazing. Thank you for everyone for your support. But with that, we'll get to it. Blair, take it away.
Thanks, James. Happy New Year, everybody. And we have now entered into the family law section, which is really my bread and butter and what I do. We probably could spend 12 months talking about family law matters. And, we're going to do a 3-part series tonight. We're going to talk about custody and parenting time. Next month, we're going to do child support. And then in March, we're going to do paternity. So we're going to get started here tonight. I want to start out with a couple of high-level things first before I jump into the meat of this. So I've been in private practice for this is my 12th year now. And I would say over 50% of my caseload is family law, and that's divorces, custody, paternity, child support. There's also probate is kind of quasi, it's guardianships. But I've been, I do what I do because I want to help families, and that's really, I think, where I do the best work. And it's the most taxing because I know a lot of other attorneys don't do family law because you're dealing with a lot of emotions. We're talking about kids in most of these cases, not always. It's a lot of emotion and fear and anxiety and stuff. So, my one of my guiding lights has been to, that I got to work to treat the fear and anxiety first with information, knowledge, and empathy. Otherwise, I can't really deliver a good product for somebody. And as an attorney, you got to pay quite a bit of money. So that's also one of the reasons why I wanted to do this series, is that people get a better understanding of how the process works as well as what the law is. I could tell you from doing this as long as I have, I get a number of clients who've worked with other attorneys, and those attorneys haven't taken the time to explain to them what the law is regarding, in this case, custody and parenting time. What are the factors? What's the process? And, this is your life, and you can certainly trust a lawyer to help you. But I think most people want a roadmap, and they want to see where we're going, what we're going to have to do. And so, my immediate goal is to educate people on what all this is and what it means and how it affects you, so that they can make educated decisions going forward as it affects their children. So diving into this, we'll start with terms and acronyms, and there's a lot more than this, but this is just a starting point. So we got legal custody and physical custody, and towards the end, they're going to get into what I guess the request I hear most from people, which is I want full custody. So I want to break that down. Legal custody is the decision-making authority over the major issues affecting a minor child, and that tends to fall under the heading of education, healthcare, and religion. And this is the only custody that has to be legally defined. So in the Child Custody Act of 1970, which is what all of this stuff comes from, physical custody is not even mentioned. Legal custody is. And so legal custody has to be found to either be joint with both parents or sole with one parent. Physical custody is the general living arrangement for a minor child between two parents, and it's not necessary. People, I think, want that term. I want to be the primary physical custodian for my kids, but it's not a requirement to be in a court order. And a court isn't going to find, if you have a trial or a hearing, who has physical custody. What matters is parenting time. And parenting time is a specific parenting time schedule for a minor child or children between two parents. And this is what is needed. So the parenting time schedule could be every other weekend to one parent, the rest of the time with the other. And then by default, that essentially means that other parent who has the majority of the parenting time has primary physical custody, but we didn't need to put it in a court order. Friend of the court, which I would bet a lot of people are familiar with, is an agency, or FOC. It's an agency that works in conjunction with the court to investigate, enforce, and provide accounting for child-related issues. So custody, parenting time, and child support. A motion is a court filing to modify or enforce an existing order. An order is a legally binding document that prescribes the rights and obligations of parties regarding the subject matter of the action. And in this case, custody, parenting time, and child support. You file a motion to get an order. And a lot of people get upset when the other party files a motion because they think, well, they want to do it. Yeah, they want to do that. But what matters is the order. What's the court actually going to do? It doesn't take very much to file a motion, and people file motions all the time. But what matters is the court order. And then finally, one we're going to start out with is standing. Standing is the right to bring a lawsuit as an interested party to a future court action. And in this case, we're talking about somebody having standing as a biological or legal parent of a minor child. So two scenarios I want to look at. So we got divorce, and when a child is born or conceived during a marriage, that child is presumed to be a product of that marriage, and standing in a custody and parenting time action is automatic. So if you're married and you have a child either born or conceived during that marriage, then your spouse is presumed to be the parent of that child. Until a court order says otherwise, both parents then have all the rights to custody and parenting time to a minor child. I refer to that in my practice as the Wild West phase of divorce, meaning that until you get a court order that says this, this is what parenting time is going to be between mom and dad, or mom and mom, or dad and dad, whatever. It's all, and everybody, it's whatever you want it to be, because both parents have custodial rights until there's a determination made by the court. To apportion those rights, a party typically files a complaint for a divorce to end the marriage, divide property, award custody and parenting time. But you don't have to. Some folks, not very many, but will file for legal separation, which would keep the marriage intact, but allows the court then to issue orders, including orders for custody and parenting time. Again, it's fairly uncommon. When a child is born or conceived outside of a marriage, the parents may have signed an affidavit of parentage, or an AOP, at or before the child's birth, attesting, swearing that the father, the male, is the biological parent of that minor child. And when they sign that, that gives dad standing to seek custody and parenting time. Now, what a lot of people don't necessarily understand, and probably mostly dads, is that AOP, in very small print, awards the birth mother sole legal and physical custody of the child until a court order says otherwise. Meaning, the father has standing to file an action, but because there's no marriage, then at least the law as it is today says that we're going to give sole legal and physical custody to the mother, and the father can file an action in court to change that, but the affidavit has to give it to one parent, so somebody has that authority, and by default, it's the mother. If an AOP was not signed by the parents, then the alleged father has to file for paternity. We're going to talk about paternity in a couple of months. So one final note then is just as a practice tip. So if you have a case, or somebody who has a case, every case has a number, right? And it's helpful, I think, to understand, what does that number mean? So the number is year, so 2024 dash, the unique number for that particular case, and it's sequential. When somebody files an action, it is sequentially assigned that number. The third one is the case type, And those case types are underneath here. So a DM is a divorce with minor children. DC is a domestic case with custody, meaning there's no marriage, but custody has been pled. DP is for a paternity case, and DS is for a support case. And then the last part of it is the initial, that is the judge assigned to the case. Now, every county's labeling is a little bit different, but that's the general rule of thumb. So that it's helpful to know if you look at your file, hey, I've got the very last initials an R, then my judge is in Berrien County, it's Judge Berger. Or the court then can see if it's a DM that this case was the result of a divorce with minor children, as well as the year when it was filed. I got a question from Kamara. We'll get to that towards the end when we talk about modification, Kamara. All right, so what's the process? To establish custody and parenting time, you got to start by filing a complaint and a summons. In other words, if there isn't an order already, then somebody has to actually initiate litigation by filing a complaint. And the clerk will give you a summons, and then you have to go and serve the other party with that summons. Whenever there's children involved, there's a number of other documents that also have to be filed. One for interstate custody issues, just to make sure there are no other states or third parties out there who might have an interest in custody in this case, as well as some financial forms. If you need temporary relief and you start a new case, then it's wise to file a motion for temporary relief, because depending on the type of case, you may not end up actually getting a trial date or a final order anywhere from 4 to 6 or 9 months down the road. And so a motion for temporary relief is, what are we going to do about custody, parenting time, and child support while this case is pending, right? And again, until you do that, you're in that Wild West phase, which means depending on the setup, somebody has all the rights or both parties have all the rights. And so filing a motion for temporary relief is also wise. You got to serve the other party a copy of those documents, and they have 21 days to file a response. If they've been served by certified mail, they have 28 days. It's in small print, but it really should be large. I want you to know, failure to file a response in your case, if you are the defendant in an action, may result in the court making a determination about custody and parenting time without your input. And it's what's called a default, meaning you were given notice that a lawsuit was opened involving a child to which you are an interested party. And if you fail to respond in order to proceed to a final order, you have to be shut out in order for that party to move on and actually get the relief they're requesting. So I've come across it in a number of cases in my practice where people have not filed those things. And then, they're reasonably upset that something happened and they don't like what happened, but they didn't take the initiative to say, I want to be involved in this case. I want to say. So it's very important that if you've been served, that you file a response. Get a lawyer, go to the Self-Help Legal Center, whatever you need to do. But doing nothing is doing something, and it probably is not going to go well for you. Once a party has filed a response, then the court's going to issue a scheduling order, give you a trial date, make a referral to go to mediation prior to trial, and you may also end up with a hearing date on the temporary issues. At the conclusion of that process, either by trial or by agreement, the court's going to issue a judgment or an order that defines those rights and obligations of each party with respect to the minor children. One other practice tip, because of where we're at, we get a lot of people coming from Indiana. In Michigan, the law is that an order for custody has to include parenting time and child support. That's not the case in Indiana, which I only know. I'm not a lawyer in Indiana, but I know it from seeing people come across with Indiana judgments, is that Indiana and other states can order a parent to pay child support without granting that parent parenting time or custody. That's not the case in Michigan. It's a package deal. The court has to enter terms or provisions on all three of those issues whenever a child-related matter is filed. So why does the process matter? I love to look at statistics and use statistics in my practice because it's going to tell me and help folks know kind of where this thing's probably going to go. One thing that's interesting that I've learned is that in 75% of all civil cases, which include child-related cases, at least one party does not have legal representation. I think it's actually a low number. I think it's actually higher than that. The figure that I have here is actually from a 2006 study that was done. And in that study, they found that in 25% of cases, both parties didn't have a lawyer. And when you don't have a lawyer, you're referred to as a self-represented litigant, SRL, or a pro se or improper party. So if you ever see those terms, that just means that you're a party who's unrepresented. Parties who represent themselves are held to the same standard as lawyers, meaning the substance of their case may be decided by their knowledge or lack thereof about the process of litigation. And I think we're all probably familiar with this term, due process under the law. That really matters because in order for the substance of your dispute to be heard, you have to know and follow the process to get it heard. And if either party fails to follow that process to protect their rights, the court is probably going to end up deciding the outcome based to some degree on technicalities. Like I said earlier, if you don't file an answer, the court can decide it without you. That's not about you not being a good parent or something like that. That's somebody not filing what they're supposed to in the timeline they're supposed to, so that they can preserve their right to be involved. So process matters a lot. And I will say your initial custody and parenting time order matters so much. It matters so much because that becomes the status quo. And modifying an existing custody order isn't easy. We're going to talk about modification a little bit, which means because the outcome is that if your parenting time schedule has your child going to see the other parent 25% of the year, and you want to ask to have it be 50%, that's a significant change in that child's life. And so doing that requires quite a bit of work. If you start out with equal parenting time, then more than likely that's going to be something like that is going to be what ends up happening when this child reaches the age of majority and ages out. So getting that initial custody and parenting time order exactly the way you want to or close to it matters so much. That's why not engaging in the initial round of litigation could really hurt your chances to get anything more meaningful down the road. Civil trials are extremely rare. This is the other statistic. So it's actually less than 3% of all civil cases, which again includes divorce and custody, end up being decided by a judge. And I always have this conversation when I talk to a new client, because I say, listen, if we know statistically, I mean, I would say that in 2024, I'm not off the top of my head, I think I probably had 100 or so different family law cases. Some were short, some were long, but I only ended up having trials or hearings maybe in 5 of those cases, 5 or 6. So it's very rare, which means that the most likely outcome is going to be you and the other parent sitting across a table in some version of that, signing an agreement. And that really matters, and we'll talk about that down the road. But to be in the best bargaining position to negotiate a settlement agreement in your favor, you have to keep alive that option to have a trial, meaning you have to follow the process. If you don't follow the process, your rights may be determined without your input. Again, even though trial is rare, you have to, as a good lawyer, I'm always saying we got to make sure we keep that option available to us by following the process. And as I've said in every single one of these sessions, listen, hiring an attorney to assist you in something like this is the smart thing to do, especially, if the child is really young and you're talking about a long, until they're 18, and this is the first round of litigation, trying to do this on your own It's really complicated, and unfortunately, a lot of cases are decided when people represent themselves by technicalities. All right. So what is a law? I'm not going to hit every single one of these, but I want to put it up there because I want people to have it. Now, again, this will be available later on if you want these slides. But you probably, if you are familiar with family law, you've heard about the best interest of the child. So that's actually from the Child Custody Act, which says there are 12 best interest factors. We'll hit a couple of them. So the court has to consider the love, affection, and other emotional ties existing between the parties, and the child. So how does a child and how does the parent express love? How do they discipline them, etc.? What is their ability to keep doing that in the future? Sometimes you have addiction or mental health issues. So while there may be a bond, that the ability to carry forward that bond may be affected, or disposition, meaning there may not be a desire by the other parent to want to continue that bond. The third one is essentially the ability to support. So having a job, ability to pay child support, meet those material needs, the length of time a child has lived in a satisfactory and stable environment, and the permanence of a family unit for the custodial home. One of the factors that comes in under those is if there's a lot of domestic violence or drug abuse in the home, it's not a stable home, right? As well as if there are additional children, if somebody gets married and now you have stepchildren, that can be a factor. Now, it's not necessarily going to mean you're going to lose custody, but that's kind of where that permanence as a family unit comes in, is when there are new significant others or other children that are coming into that custodial environment. Moral fitness, that gets into drug use, addiction, mental health, infidelity, criminality of a parent. So we're talking about the moral fitness of a parent. Mental and physical health also kind of falls under that heading. The homeschool and community record of a child is, how are they doing in school? How is your health? Are they involved in activities? The next two I really want to spend a little bit of time on. So the reasonable preference of the child. The reasonable preference is a factor that the court has to consider. And in fact, I think I'm going to talk about this a little bit later on, so I'm not going to spend too much time here. But the court has to make confidential inquiry of the child as to who the child wants to live with. And it's not the determining factor, but it is a factor. But the child has to be old enough to be able to give an independent, reasonable preference. This happens behind closed doors. It's kept confidential and not shared with the parents, so that the child doesn't feel like, they're going to be found out if they tell their truth, and it might hurt mom or dad's feelings. The next one, willingness and ability of each party to facilitate and encourage a relationship with the other parent. That's a big one. This is factor J under the law. And, to the degree to which one parent is encouraging the child to have a positive relationship with the other parent is a big deal in family law. And I see a lot of cases get decided on that factor. Domestic violence is obviously, a significant concern in the impacts on a child. And then there's the catch-all factor and any other things. In addition, there are 9 parenting time factors that look at, okay, we're going to do what's the parenting time arrangement, frequency, duration, and type of parenting time that's best going to suit the child. I won't go through all of these, but I'll say, if you got a very young child, then obviously that's going to have an impact, because having an infant go week on, week off, especially if they're nursing, is not reasonable, versus a child who's 10, 11, 12. Maybe they have special needs like autism or something like that. That's a material factor under this part of the law. Whether or not there have been denials of parenting time, whether somebody's going to follow a court order if a court order is entered for parenting time, withholding the child from the other parent, the distance of travel between parents, That's a big one. I do a fair number of cases where one of the parents lives several states away, and so we're allocating parenting time, by concentrating most of the parenting time during the breaks, because when a child is in school, you can't really travel, several hours away for a weekend. So that is definitely a factor. There is a presumption, and it's in the law, that it's in the best interest of a child to have a strong relationship with both parents. That doesn't mean that 50-50 custody and 50-50 parenting time is going to be the outcome. But I will say, based on my experience of doing this for over a decade, most judges start with that as this is what probably is best. And so you have to then convince the judge or the referee that we should do something different. Because there is this legal presumption that a strong and positive relationship is good for the child. But of course, parents have real serious issues that affect their ability to be a parent. The court's going to consider that. I want you to hear me say that. It's just that there's a lot of energy towards having some kind of an equal parenting time arrangement. A child has a right to parenting time. And this is the way the law is phrased. Child has a right to parenting time with a parent unless it is shown by clear and convincing evidence that parenting time would endanger the child's physical, mental, or emotional health. I see a fair number of people who don't want the other parent to have any parenting time. It's so difficult. It's extremely difficult and extremely rare to get that. And this is the legal standard that says there's got to be very obvious, clear, and convincing evidence that allowing that time is going to endanger the child. Outside of that, parenting time is going to be deemed to be appropriate. There's other factors, or not factors, but conditions that the court can impose on parenting time. Conditions, one of the ones I see a lot is if there's a concern about alcohol and drug use, is to say both parties are not going to engage in drinking or use of drugs, even if they're legal, during the exercise of their parenting time. So that's a condition that doesn't affect the schedule. It just says we're going to put some restrictions around that parenting time to, better protect the integrity of the parenting time and the child's safety. Couple things here with, legal citations is the weight ascribed to each custody factor, which are the 12 that we had earlier, is at the discretion of the court, meaning the court needs to look at all of them, and they can give some factors more weight than others, and it doesn't have to be equal. And then finally, reasonable rights of parenting time, which you see in a lot of orders, and a lot of orders that are what we call default, where the other party didn't engage, that parent may get reasonable rights of parenting time. So that is a schedule that is defined in the front of the court handbook. And I'm going to talk quite a bit about Berrien County because this is where I primarily practice. However, every county has their own front of the court handbook, and that reasonable rights of parenting time may be a little bit different depending on the county where you live. And in Berrien County, reasonable rights consists of every other weekend, half of the summer break and Christmas break, and then shared holidays on an even year, odd year alternating schedule. And if you have ever seen the handbook or need a copy of it, you can get it online. You can go to the front of the court at the courthouse and get it. But if you open up the middle of it where the staples are, that's reasonable rights. So it's right there in the middle, and it'll tell you exactly what it means. That comes out to about 90 overnights a year. So that's establishing. Let's talk about modification. To modify an existing order for custody and parenting time, a party has to file a motion. So you have an order, file a motion because I want to change it. When you file that motion, you have to allege that there's a proper cause or a change in circumstance. Those are legal terms. Since entry of the last order that would warrant modification of that custody order. The motion also has to say, what changes do you want? So do you want to change legal custody from joint to sole? Do you want to reduce parenting time? If so, to what schedule? you have to be clear as to the request for relief that you're seeking from the court, and how you want to change the order that's already in place. You do all that, you get a hearing date from the court, then you have to mail a copy along with that notice of hearing to the other party's home address. You don't have to personally serve them, but you have to send it to them, because when a child custody case is started, the court has continuing jurisdiction over that matter until the child turns 18. So you don't have to do personal service anymore. You just mail it to them at the home address that the friend of the court has on file. So another piece is that make sure if you move, you update your address with the friend of the court, because that will fall on you. If the other party files a motion and sends it to the address that's on file, they will have followed the process, and you will be at fault, because there's an obligation in your current court order, in every court order, that says you need to maintain a current address. So process. The court is going to refer the case to mediation, or what's called a facilitative information gathering, or FIG session, prior to holding the hearing, to see if you can reach an agreement. And again, come back to statistics say that overwhelmingly all these cases are going to settle. So alternative dispute resolution is what's called ADR. I'm a mediator, been mediating for I think 9 years now. That's that process, is to try to reach an agreement before you end up having to go to court. And it's usually successful, not always, but usually. If that isn't successful, the court's going to have a hearing if there's no agreement, and then they're going to consider the evidence and issue a new court order if the moving party has met his or her burden of proof. And we're going to talk about burden of proof shortly. These hearings are conducted by attorney referees. They're not judges, though they operate in a similar fashion to trials in front of judges. So, family court is packed, just packed with people filing motions all the time. The number one motion that somebody files in family court is, I want to change custody. And not necessarily they know what that means. They just want it to file a motion. So the family court docket is bloated with cases. And if you had to wait to get in front of a judge on every single case, you probably would end up having to wait over a year to get a hearing. So it's been in place for a long time. Referees are attorneys hired by the court to hear these cases before they get to a judge. So they happen in front of a referee. That's why if you go to these hearings, you'll notice that these attorney referees are not wearing robes, because they're not judges. They're just wearing, suit and tie or whatever, nice clothes. But everything else about it feels like a trial, feels like, you're in with a judge. If either party disagrees with the order, the outcome of that hearing, then you have a right to what's called a de novo, Latin term for, have a review, a new hearing by your trial judge, meaning you have that automatic right to take it up to your judge and have that judge decide whether or not the referee did it right or wrong, applied the law to your facts correctly or incorrectly. Rarely are those successful. Rarely do the judges overturn, and they're not necessarily going to have another hearing. More likely, they're going to review the transcripts of the hearing and review the exhibits that were admitted, and then make a determination. And those transcripts, depending on how long the hearing took, can cost a lot of money. So your referee hearing is, for most people, the end of the road. And appealing it up the chain generally does not change very much. It'll happen occasionally, but very, very rarely. All right, so what's the law? Modification of a prior custody or parenting time order is a 3-step analysis. And again, this is a part that I don't think a lot of lawyers spend time explaining to people. I wish they would. Well, I try to make a point every time I talk to somebody to help them understand the 3-step analysis. Number one, is there a proper cause or change in circumstance that warrants modifying? Having a hearing and reevaluating custody takes a lot of work and a consideration of a lot of evidence. So there's a threshold question. That's what this is that before we even get into that further analysis, is this a valid reason for us even being here today? And And the reasons to change the court order have to have occurred after entry of the current order, meaning, and it's a judicial efficiency thing, that you can't go back and relitigate things or bring up events that predated the order that's currently in effect. Because if those events mattered, then either they were already considered at a hearing or you waived your right to bring them up in this subsequent case. So we're only talking about things that have happened. If your order was entered in November of 2022 and you're filing a motion in January of 2025, we're only talking about the stuff that happened in that 2-year period. All right. The requested change or changes need to be aligned with the basis to change the order. In other words, if a parent is scheduling doctor appointments without the other parent's consent, asking to change the parenting time schedule is not going to fix that, right? Your solution has to solve the problem. Otherwise, it's an easy, no, we're not going to give you that. So the proper cause has to align with whatever your request for relief is. And the degree of the change being requested has to align with the severity of the reasons for the change. Example, a parent seeking to suspend the other parent's parenting time because that other parent lets the child stay up too late is not in alignment. I mean, they're not going to take away somebody's parenting time if your kids are up late. They're not going to necessarily take away somebody's parenting time if they miss a few days of school. Degree matters. And I can tell you this, that what you or I as common folks think is serious is not necessarily what a judge thinks is serious or severe. So that's that first part is, do we even have a really good reason for being here? And quite frankly, a lot of SRL, self-represented litigant filings, are dismissed because they fail to meet that standard. Step 2 is, what is the child's established custodial environment, or ECE? That's a legal term defined in the law as the custodial environment is established for a child if over an appreciable period of time, the child naturally looks to that person or persons for guidance, discipline, the necessities of life, and parental comfort. The court has to engage in that analysis to determine, does this child have an ECE with mom, with dad, with both parents, or with nobody, which is a terrible thing. If the requested change, if you're looking to change the parenting time, let's say, is going to alter that ECE. Now, let's say the ECE is with both parents, and you're seeking to now have the child live with you the majority of the year, and that is going to mean that child is going to look primarily to you now, rather than both parents, as the custodian for guidance, necessities of life, all those things. Then the burden of proof is clear and convincing evidence, which is the highest burden of proof in civil court. It is literally shock the conscience of the court. If somebody told you this information in 3 sentences or less, you would say, "Oh my God, that has to be a change." And again, what is serious for parents is not necessarily what's serious for a judge. And that's really akin to, I tell my clients, beyond a reasonable doubt in criminal court. It's not, but they're kind of the same. It's really difficult. If that requested change is not going to alter the established custodial environment, then the moving party only has to show that the change they're seeking is in the child's best interest by a preponderance of the evidence, which is slightly more than 50% that what they're saying is true. That burden is, so in other words, if what you're asking to do is only going to tweak things a little bit, that request is a little bit easier to get, right? Than the over the moon child living with dad 25% of the year, and now dad wants the child to live with mom 25% of the year. The swing of that pendulum is so great that the evidence has to be just overwhelming. And in most cases it isn't, unfortunately. Number 3 is, having established and determined who has that ECE, now we evaluate those 12 best interest factors that we talked about earlier on. So the court goes through that analysis and finds which parent is favored under factor A, factor B, factor C, and then that leads to the outcome. So how long does all this take? Doesn't take very long to file a motion or complaint and get a hearing date. People can do it, and it costs $100 to file a motion. It costs $255 to start a new case. But if you're on state assistance, you can generally get that fee waived. So it's really just a matter of paperwork. It doesn't just fill it out, file it with the court, you get the hearing date. So it doesn't take that long, which is why a lot of people do that, because it's relatively easy. You got to allow that few weeks for the other party to file a response. Your hearing date is generally going to be 2.5, 3, 4 months out into the future, and you're going to have to mediate before you get to that hearing date in order for the court. Right now, and it's been this way for 3 years in Berrien County, everybody has to go through mediation before you can get to a trial. If you haven't mediated yet, you're not going to be allowed to have a trial unless there's domestic violence or some other reason, which is rare, to disqualify the mediation requirement. You got to do that mediation before you can have that hearing or trial. You got to prepare for your case during that waiting period. The hearings can take, at minimum, the standard in Berrien County is if two parties are unrepresented, they schedule it for 2 hours. Though these hearings can go up to being several days long. I had a case that I wrapped at the beginning of last year that started the year before that went on for 11 months. We had, I believe, 7 different days in court scattered over that period of time, a half day here, a full day there. And the outcome was that the motion that the other party filed against my client was dismissed for failure to show a proper cause or change in circumstance. Unfortunately, that cost these people an exorbitant amount of money. And it was really quite frustrating for me to be on the other side, knowing what I was up against, because my client had to take it seriously, even though she didn't want to litigate, but she had the motion filed against her. So these things can drag on, and it gets super messy because when these things get scattered out over several months, new things happen, right? It's not like the world stops turning. New events happen in between hearings, and now you got to deal with that new information when you get back into court. And then the referees have to, everybody has to refresh because so many months has gone by. What did we do when we were last in court? Where did we leave off? I mean, just think about the efficiency of this thing. It's just a nightmare. Once you finish the hearing, it can take anywhere from a few weeks to 4 or 5 months, I've seen, to get that final order. The courts are backlogged and it takes a long time. I don't know why, but so you're waiting and waiting for the actual order, and then you have that right to an appeal. You got to do that within 21 days. The timeline for these cases, typically for complaint when you file for divorce, can take up to 9 months, though parties can be done within 6 months or at 6 months after the date of filing. The court will take an agreement, or even earlier, up to 2 months after 2 months, if there's a really good reason to wrap it up. Motions to modify, again, can take, at minimum, usually it takes from the day you file until the day you wrap up in court, about 3 months at a minimum, but it can take, in some cases, over a year. And in fact, I mediated a case just last week where the motion that had been filed had been pending since October of 23, I think. And that motion was still pending. So I want to be honest about when you start something, it may take a very, very long time to get it done. So what is all this? No, I'm going backwards, not backwards. So now I've allowed myself 15 minutes. I was hoping 20. This is the lawyer tip section. This is the demystifying. This is the, how can I help folks who are who aren't lawyers, understand what you're going to achieve if you decide to engage in litigation. What's realistic and what isn't, and demystifying this thing to try to, for my sake, really, to minimize the amount of people going to court and suing to change custody and parenting time. So I want full custody. This is the most common thing that I hear when people call me. I'm not bashing people when I say it's a statement of fact that this is what most people are seeking. And we got to unpack it. All right. So what does this mean? What does it actually mean? Joint legal custody, like I said earlier, a shared decision-making authority over where the child's going to go to school, who their doctors are going to be, whether they're going to get braces, whether they're going to start, maybe they need a new surgery or need to see a specialist, or maybe they're going to be confirmed in a religion. Those are the major decisions, right? That major decisions are not where we're going to go out to eat, what time are we going to go to bed, are we going to go to Florida for vacation this summer? That's not a joint legal decision. That falls under the heading of parenting time, and the parent exercising parenting time has the authority to make those decisions without involving the other parent. Sole legal custody means only one parent has a right to make that decision. The other parent has a right to information. I don't know if that's common knowledge or not, but by statute, even if you don't have legal custody and the other parent has legal custody alone, you are still entitled to get your child's school records. You are still entitled to get your child's medical records. I will say that in my experience, most schools and medical professionals are not aware that that is the case, but it is by law separate from any court order that says a parent has sole legal custody. So there's education that's needed in the other sectors about what a parent who doesn't have legal custody is entitled to. Information. It's your kid. You're entitled to that information. Being awarded sole legal custody is very, very rare, right? Often it's only when the other parent is not involved in the case, they've chosen not to engage, or they're incarcerated, or they have some other serious issue that impairs their ability. Sorry, no, it's something else. Or I'm losing my train of thought here. Or some other issue that impairs their ability to make decisions together, right? So if there's a PPO, there's domestic violence. But I will say this: there is a general, preference in all of the work that I've been doing in various counties. Courts want both parents to have a say in how these major areas of their child's life are going to be dictated. That doesn't have anything to do with parenting time. It literally is how is your child going to be educated, and having a voice and a say in a decision-making ability in that matters. And so sole legal is very rarely granted either at the initial level or at modification. However, as I say on the bottom, the main reason the court will take away joint legal and award sole legal to one party is when it's very clear that the child's well-being is being affected. In other words, the parties fight so much, or one of the parents is clearly obstructive. They don't want to agree to anything that the other parent offers. And as a result, this child can't get the medical attention they need. As a result, this child is falling behind in school. Those are the scenarios, which are hard to prove, but you can, that a court will say, all right, we now have to empower one parent to make these decisions because the two parents cannot agree. And in my experience, most courts want to start with joint legal, see how it works before they take it away from somebody. But in all honesty, when people call me and they say they want full custody, they're not really talking about legal. They're talking about physical. I want the child to be with me either majority of the year, meaning that the other parent probably has reasonable rights of parenting time, a quarter of the year, or he or she does not want the other parent to have any parenting time at all. I state the legal presumption again, that there's a strong bond desirable with both parents, and that to not have any parenting time requires clear and convincing evidence that the child's life would be in danger. Getting sole physical custody is extremely hard to do, and full stop on parenting time is nearly impossible unless that other parent is incarcerated, they're completely absent and have been absent for a long time, we don't even know where they are, or they're several states away. Those are the scenarios where you probably get that, but those are rarely the scenarios that I see in my practice. Full custody motions are the most commonly filed. So think about it this way. If it's the most commonly filed, then it's the most commonly heard, meaning that the judges and referees really know how to handle those, right? So they're very well versed in how to deal with a change in custody motion because it comes up most frequently on their dockets. So they're going to know the law. They're going to know what they're looking for in the facts. And because most people file these without lawyers and they don't know what they need to say or what they need to prove, they're often denied at that first step of the three-part analysis. What a parent thinks is serious is rarely ever as serious as a court thinks. So there's a case that says clear and convincing evidence. It has to shock the conscience of the court. I tried this earlier on in my practice when I was just getting started. The kitchen sink approach, it doesn't work. So if you're like, well, taken together, this, and this, I think the judge is going to see, that very clearly I should be given full custody. No. It's generally not the case. You got to have that, boom, shock the conscience, 3 sentences or less. This is what happened. And we'll talk about what that evidence is a little bit later that shocks the conscience. And a parent being awarded 0 parenting time or even less than 90 overnights a year is really hard to do. And even if their parenting time is suspended, the law requires their case to be set on a review schedule. And it's usually like every 6 months or so, come back into court. How are you doing? Because usually it comes with some conditions, right? Your parenting time is suspended until you go and you do a mental health evaluation, or you have to go and do a parenting class, something like that. And so they want to see your progress. In my experience, our courts are bending over backwards to try to get non-custodial parents to reasonable rights of parenting time. That's not in the law. It's not anything it's just that based on my years of doing this, I see there's a lot of momentum and desire to want to get the non-custodial parent to a quarter of the year wherever possible. Now, if they live several states away, that's probably not going to be possible, right? But just be aware that comes from that presumption that a strong bond with both parents is what's best for this child. Another common thing is my child doesn't want to go see mom or dad. I want to break, there's no age in Michigan law where a child gets to decide where he or she wants to go for their parenting time. They don't get to make that decision. When they're 18 and they're adult and they're no longer subject to the jurisdiction of the family court, then they can decide. But I want to break you of that wish. I think it gets passed around that maybe that's true. It's not true. Reasonable preference is one of the factors. It's not permitted by law to be the sole deciding factor. The court has to look at the other factors. The court will grant, in my experience, a little more weight to a child's preference as they get older, right? So a child's preference at 6 or 7 is going to be different than their preference at 16 or 17, because and I appreciate our judges that I've been in front of. They recognize, this child is beginning to develop their own life, right? And so frankly, at that age, or even younger, the child doesn't really want to have anything to do with mom or dad. They want to hang out with their friends. So forgive me if they just want to do their thing, even though they can't make that decision. A lot of the judges that I've been in front of acknowledge, that a child's desire to be more independent matures as they get a little bit older, and they honor that, which I think is great. I think it's important to do that. Refusing to allow a parent court-ordered parenting time may get you in a lot of hot water. It could expose you to contempt, and if it happens multiple times, the court can use that as a basis to take away your parenting time. Don't just flat out deny parenting time. If you don't like what's happening, or if the other parent is not using that time on a regular and consistent basis, file a motion. Seek to modify your order. Do it the legal way, because doing it on your own could cost you eventually, in the end, the custody rights that you currently have. If you are being denied parenting time, You first have to be in full compliance with your court order. Got to know your court order. This is what I'm supposed to do. And a lot of this comes from the friend of the court handbook. And this will be at the end, but I'll do my PSA now as well. Please read this. This is Berrien County's friend of the court handbook. If you have a child and you have a court order and you don't have a copy of this, you are really hurting. You're really hurting yourself, because your court order dictates high level things, but there's a lot of other information in here that fills in the gaps. And I think the number one reason why people are frustrated and they get into trouble is they haven't read the documents that are dictating the rights that they have. So get a copy of that handbook, because that handbook talks about, if you're being denied parenting time, what do you need to do? And the first thing is, you have to go and attempt to pick up your child. If you don't follow the order, you say, well, she's already texted me, I can't see this child, I can just go pound sand. Well, then you are not going to be in position to say I was denied my parenting time. You have to go and make the attempt in accordance with your court order and the friend of the court handbook to be able to file with the court that you were wrongfully denied your time. If you listen to the other parent and don't do that, then it will be treated as if you are consenting to their bad behavior. Because here's the thing, your kid doesn't know, right? I mean, hopefully they have no idea hopefully they know what the schedule is, but they don't know whether mom or dad's going to come, and they don't know why necessarily. They just know that mom or dad is not showing up, right? And if that happens often enough, because the other parent is like, well, mom's not going to let me, or dad's not going to let me see my kid, then your child is going to only experience the absence of your presence, right? The absence of your presence is one of those custodial factor issues, meaning that if you don't, like I say at the bottom, if you don't know your rights, if you don't exercise your rights, if you don't enforce your rights, you may lose your rights. And so much of this is really, again, and I don't fault people, as they listen to the other person and they think that they're calling the shots because they have primary custody. No, I've had these cases where people have come to me and they have a court order that gives them a schedule with rights and time, and they don't even know it. You've got to know your order. You've got to and talk with the friend of the court about it if you have some concerns. All right, we're running out of time here, but I may go a little bit long. Stay with me tonight. I've got the evidence to win my case. Okay, remember, what a parent thinks is serious and what a court thinks is serious could be two very different things. He said, she said cases will not meet the burden of clear and convincing evidence to deviate from whatever that norm is, right? The best evidence that you can have in your case is objective evidence. Objective evidence are police reports, preferably ones that lead to charges and convictions, right? Criminal histories that substantiate behaviors that actually impact a child, like assault behavior, drug behavior, sex offenses. What doesn't affect a child? Fraud, right? So again, alignment, right? So think about, is this evidence actually not just that it's a bad thing, they committed a crime, but how is this affecting this child? That's what matters. CPS reports. And again, CPS reports that substantiate abuse and neglect. Anybody can make a call to CPS. And they'll go out and they'll investigate. And if there's no finding of abuse and neglect, then that report is worthless to you as a basis to try and modify. Counselor's testimony, that's a big thing. I use counselors in a lot of my cases. Not because I want to put counselors in the middle, but because we want to have an expert who's able to determine, objectively, how's this child doing? How are they doing in the current custodial environment? Is it working? What's not working, right? And then that counselor can offer testimony as to whether or not a change may be necessary. School records, and we're talking about significant absences or tardies, not just here and there. Those school records, right, can't be refuted. Medical records that correlate with a concern that a child's medical needs are not being met by the other parent. All right. So this is not the text messaging back and forth or the Facebook messaging. I can tell you I get a lot of those. This is the hard third party, higher level folks who work with this child and can say, I have some concerns here. Or with a parent, I have some concerns here. Criminal behavior, mental health issues, addiction, whatever it might end up being. Getting the evidence before a judge or referee requires an understanding of the rules of evidence. Okay. How many times I've had people say, well, I had it all there. I came into court for my hearing with my binder and the judge wouldn't look at it. Well, no, it doesn't work that way. You got to know, process how to get this evidence legally admissible, because not all of it is, you know. And again, having a lawyer knows what they're doing. It's a way to do it, because your lawyer may say, listen, this isn't admissible. Not everything is. But you may have great evidence, but if you don't know how to have it actually admitted, and just dropping it off at the front of the court or attaching it to your motion and filing it with the court does not mean it has been admitted. It's got to be admitted under the rules of evidence. The court, as just a warning, all right, the court is always going to choose the path of least resistance before reducing parenting time or changing custody. So in my experience, they're always going to add conditions. All right. So if alcohol is a problem, we're going to put a restriction on alcohol. Right. If there's a third party who's causing issues, and again, serious issues, then we can put a provision on there. Before they take away somebody's parenting time, they're going to try the soft measures first. Just keep that in mind. I don't think that really falls under evidence, but I wanted to tuck that in there. So finally, and then we'll get to a couple of takeaways. And I know we're at 7:01, so please stay with me. The friend of the court is biased against me. I hear this, not a lot, to be honest, but I hear this. My own personal bias. My wife used to work for the friend of the court, so I got a little bit of bias there. Each judge, just so you understand how this thing works, each judge is assigned 2 friend of the court investigators, and that's usually who people enter. There's a lot more other people there, but the people that mostly a parent is going to interact with is their friend of the court investigator. And this is in Berrien County, I should say, this judicial assignment thing. Not every county has investigators. Cass doesn't have investigators. Van Buren doesn't have investigators. But in Berrien County, each judge has 2, one assigned to the first half and one assigned to the second half of the alphabet based on the father's last name. The investigator's job is like a social worker. So their job is to educate parties on FOC policies, affirm what the court order they have says, help parties resolve disputes, either through writing letters or doing one of these FIGs, a mediation, and enforcing court orders. Child support division is a totally separate division. We'll talk about them later. What I'm talking about is the custody parenting time side of FOC. The FOC investigator is likely going to be asked for a recommendation at the hearing based on what a party is requesting. Now, that recommendation will be offered, but it's not binding on a judge or a referee. But, your investigator probably has the most experience outside of the parents with the case and with prior litigation and things, and judges and referees value that input and will consider that input as part of their final decision. Friend of the court is not attorneys. They're not even advocates. They're not an advocate there for parties or children. They're there to oversee the administration and compliance with child-related provisions and court orders, and to assist in mitigating further conflict. Perceptions of bias, in my experience, are more attributed to a parent's lack of understanding of FOC's role and authority, and a lack of understanding of the legal process, rather than some actual bias from the friend of the court. And again, I think it's just that it's a super complex system, right? And an easy button, frankly, is to blame the system for the outcome, including a friend of the court. But in most cases, it's a lack of information, lack of knowledge. Coming after your friend of the court investigator is a surefire way to hurt your case and lose your credibility with the court. Not going to make a judge happy or a referee happy if you are bad-mouthing an investigator. Now, there's a grievance process. So if you don't like the investigator, there's a formal process like everything else and it's in the handbook in the back about if you have a grievance against your investigator, This is how you go about doing it. Do that. Okay. Don't lash out at them at the hearing. All right. So final thoughts here, and we'll wrap up and take the questions that came in. Get copies of your court order. Read your court order. Get copies of the handbook. Read the handbook. Like, so much of this is really about self-education and understanding what are the provisions in place that are affecting you right now. Because if you don't understand what your rights and obligations are right now, how are you going to know whether or not and how you need to change them? So you got to make sure you get those things. Attempt to resolve your dispute with the other parent outside of court first. You can use the FOC, a mediator. You could use an attorney like me. I'm a settlement-oriented attorney. I've been told that I'm soft a little bit and whatever. I don't necessarily want to be known as a shark. I'm realistic, because I say 97% of the time people are going to settle. So why don't we start there? And settlement usually saves you quite a bit of money. Think about my 11-month long case. Those people drop 20 grand. And I'm not violating confidences when I say this. I just want you to know how expensive this can be. In that case, didn't change a thing. Most people that I work with don't have that kind of money to throw around. So again, not everything is going to settle, right? But I want to be honest, like, really give it your best effort, because when you file your motion, you're going to have to go that way anyways. So maybe you try it before you file. Now, it takes two. If the other party's like, forget you, I'm not talking to you, I'm not doing that. All right. So, well, you're going to have to file. Remember that your relationship with the other parent does not end when your kid turns 18. They're going to be there for hopefully the rest of your kid's life. I mean, I would say, well, they're going to be there for a very long time, and hopefully your kid is going to outlive them, which means, guess what? Spoiler alert, they're going to be at all of the big events. Maybe not, maybe a parent is just not engaged, but they're going to be there. Let's assume they're going to be graduations, births, birthdays, things like that. Like, do you want this person to still be a thorn in your side when your kid is now having kids because you still have a beef with them? Just something to keep in mind. Like it or not, your child is half that other person's DNA. All right. You had a kid with this person, whether it was, now I should say, listen, if it's a result of sexual assault, the law deals with that very differently. That is a rare thing. But in all other cases, parents did what they had to do and they made a child. And so if you degrade that other parent, guess what? You are degrading your child to a certain degree, and that is going to have an effect on them. So don't do it. I mean, it's okay. Have your thoughts and your feelings, vent where you need to, but don't do it to your kid. It doesn't help. It's not going to help at all. If litigation is necessary, be sure you keep thorough records, and remember that objective evidence carries more weight. Document. Like, that isn't going to be the thing that wins your case, but it's going to help so that you've got, and I've had clients who come in, they got a calendar, they got all this written out, right? They've kept track of the weekends that were supposed to be the other parents, and they failed to show. That's the kind of thing you may need. Be aware the legal process moves very slow. New events come up. And so protracted litigation is what we're talking about here. It just goes on and on and on, is unending. The 2-year-long case that I mediated last week, it sucks, right? Because you can never get your feet underneath you, and it will cost not just money, but it's stress and anxiety and angst. It's just toxic. What you think is emergency is probably not what the court thinks is an emergency. People can file for an emergency motion, which means I want you to do this before you even have a hearing. Rarely is it ever granted, and rarely does the court really think that it's an emergency. Degree, alignment, right? Make sure that your proposed solution is going to fix the problem. Those things matter. And then finally, my pitch for lawyers like me, this comes from one of my referees that has been doing this and bearing it for a long time. And I love this. She says, she'll say this to people at a hearing, when you need a root canal, you go to a dentist. You don't do it yourself. So why would you do this in family court, right? Like, if you have a serious issue that's affecting a huge part of your life, why are you going to try to do this on your own? Because, the big difference is Google, right? There's more information out there and available to you today than ever before, right? It just gets bigger and bigger and bigger, right? But information isn't necessarily correct information, and information isn't 3 years of law school and passing the bar exam. Okay, I'm not trying to pat myself on the back here, but this is what this referee's message is listen, when you have a serious problem, you go to a professional, right? And I get it costs a good amount of money to go to lawyers, but thinking that you can find the answer online and use that in court usually doesn't pay off, and it usually ends up, wasting a lot of money and time and stress. So that, I think, is my standard, right? And this really could be a much longer list. What we didn't talk about, right? So we didn't talk about CPS. That's a big part of this, okay? Like CPS and the interplay with custody and parenting time, that could be an entire other segment. A deeper dive into the friend of the court. The friend of the court can be your advantage, right? Part of it is that this friend of the court handbook can tell you what you can do on your own without hiring a lawyer to enforce the rights that you already have. That's one of their jobs. So they can be not an advocate for you personally, but they can do some of this stuff for you if a party is not following a court order. So we didn't talk very much about that process. Self-representation. What do I have to do to represent myself? There is the Self-Help Legal Center in Berrien County on the second floor at the courthouse. There's also MichiganLegalHelp.org. I will say this, that in the last decade, Michigan has thrown in a lot of money and time into getting information out there for people to represent themselves, but having a lawyer will really, help. We didn't talk about appeals, and we didn't talk about paternity and child support. We're going to talk about that in the next couple of months. So any other questions? I'm going to get to Kamara's in a second. Sarah, thank you for your question. I owe you a call. And this is the dates coming up that on the 20th of February, we're going to talk about child support. 28 days later, we're going to talk about paternity, and then we're going to wrap the series with guardianship. Kumar had asked about how do I change a court-ordered bridging schedule. Do you have that up in front of you, James? I might be able to pull it up. Comments. I see it here. All right, Sarah's got a couple of things in here. We didn't talk about ex parte orders, and we didn't talk about submitting evidence with ex parte orders. Ex parte means without a hearing, it means without the other party, which basically means we're going to do this without a hearing. Ex parte relief is rarely granted. You can file it, but just filing an ex parte motion again, that requires really a serious. What's happening with that, so you folks know, is that the court is making a decision without hearing the other side, right? And so it requires quite a bit. It's a really high burden to meet, I should say. And then Kamara, what do you do when you do not agree with the bridging schedule that's ordered? So Kamara, you got to file an objection to the bridging schedule. And if this is something, so we didn't talk about friend of the court supervision, that really should have been on the list too. But if a bridging schedule has been entered, issued by the friend of the court, then the friend of the court will have a cover letter that they say, okay, if you disagree with this, then you have 21 days to file an objection, and then they'll schedule it for a hearing. So that's that requirement there. We are at 7:15. It's been a long night. I appreciate y'all sticking around with me. Like I said, this is something we could spend quite a bit of time on. We talked high level stuff, but process and law education is really important. I love doing these sessions. I love that they're out there for people and they can access it whenever they want to. You can share it with people because I think a lot of money, time, stress, energy, fear, all that stuff could be saved if people really understood how all of this worked, right? How the sausage was made. So that's one of the things I'm here to do. Thanks for the chance.
Oh yeah, thanks again, Blair. We have 3 more sessions: February 20th, March 20th, and then April 17th. If you have any questions, feel free to email them to me at jgunter@presentpillars.org. I can pass those along for you, or you can contact Blair directly. I think it's Ask Blair Johnson, right?
That's the Gmail. You can just email me at blair@blairjohnson.law.
Got it.
Ask Blair Johnson is my Facebook.
Oh yeah, look, I like the plug. But good night, everybody. Thanks for tuning in. We'll see you next time. Later.
Take care.